have any children?
Yes, ma'am.
What are their ages?
4, 3, 2, 1, 6 months.
And where are they? Who are they with?
Their mothers.
How many?
Imagine walking into court facing a robbery charge, juggling 3 baby mamas, 5 kids under 6 and wearing a shirt that says Black Excellence. Bold move, right, but is it confidence? Or pure irony? This isn't just about fashion, it's about survival. Nicholas Cornelius could walk out with a clean recorder, lose up to 20 years of his life. And Judge Boyd, she's not pulling punches. What would you do in his shoes, bet on redemption, or risk it all? Stick around, because this case is about to explode with twists you won't believe.
Mothers.
3.
All right, that is not Black Excellence. The fact that you're here is not Black Excellence, unless that's the name of a building, but I'm assuming it's.
Oh boy, talk about irony. Walking into court with a Black Excellence shirt while juggling 3 baby mamas, 5 kids under 6, and a felony case? That's not the flex he thought it was. And Judge Boyd, she's not holding back.
And notice, right here Judge Boyd doesn't waste time setting the tone. She immediately cuts through the image Cornelius is trying to project. That shirt was supposed to say confidence, maybe even pride, but in this courtroom, it reads as hypocrisy. Viewers, what do you think? Would you dare to wear a slogan that bold while standing trial for robbery?
2021 CR 0835, State of Texas versus Nicholas Cornelius. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas. And Jackson Lindsay on behalf of Mr. Cornelius, Judge.
Are you Mr. Cornelius?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Cornelius, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
As Judge, we're going with the lesser included offense of robbery.
Any objection?
No.
Showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with or at least the state is proceeding on the lesser included offense of robbery? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you.
Let's pause here. Second-degree robbery in Texas is serious business to 20 years. But instead of rolling the dice with a jury, Cornelius is.
This is the heart of the gamble. Deferred adjudication is basically a second chance wrapped in handcuffs. If Cornelius behaves, the charge disappears like it never existed. But one wrong move. The judge has full authority to drop the hammer with a 20-year sentence. It's the legal version of walking a tightrope with no safety net. Would you take that risk?
Banking on deferred adjudication. Translation: if he behaves, this charge could eventually disappear from his record. Huge gamble, but potentially a huge win.
More than you bargained for. The fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to accept your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Judge. I believe he's competent.
Do you believe he's yes. Do you believe he's legally?
Listen closely. This moment matters more than people realize. By confirming no threats, no promises, and full understanding, Cornelius locks himself into this plea bargain. There's no going back later claiming he didn't understand. Just ask these questions for a reason. They're bulletproofing the record. Smart move, because appeals courts love to sniff out loopholes.
He was legally sane at the time of the offense. Mr. Cornelius, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense of robbery, and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions? Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation and no contact with Jose Aguilar. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense of robbery, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State officer exhibit 1 and all attachments. No objection.
All right. And state, have you been in contact with the complainant?
So we have been in contact with the complainant, Your Honor. There were other co-defendants in this case. One of them also did have their charge reduced to robbery and was given deferred.
All right, thank you. Oh, you may be excused to continue to confer. Mr. Cornelius, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney?
Yes,
Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Judge, we're waiving guilt by.
All right. Anything you wish to say on behalf of your client?
Just so the court is aware, Judge.
All right.
And here's the legal magic trick. Judge Boyd basically says, you're guilty, but I'm not going to say it. That's deferred adjudication in action. It's like being on probation with a get out of jail free card, so long as you don't screw it up.
All right, so everyone, please whisper in the box.
This is where law meets strategy. Judge Boyd essentially says, you're guilty, but I won't say it yet. That's the legal finesse of deferred adjudication. Imagine being told, you committed the crime, but I'll pretend you didn't. As long as you walk the straight line, it's mercy with conditions, and those conditions can flip at any second.
We're on the record. Yes.
Thank you, Judge. Briefly, my client had court in the Winnipeg District Court back on May 31st of 2022. That day, he was arrested by the U.S. Marshals for a federal charge of being a person under indictment in possession of firearms.
Okay.
He spent 15 months in custody awaiting that charge. We worked out a deal in federal court for a plea bargain, accepting his ability to appeal that sentence because that particular statute is being challenged in the upper courts right now, 922N. 18 USC 922N. So because he was denied bond, he was in a position where he ultimately pled guilty because he did have the firearms. That explains why we took so long to come back to this court. He's here now, Judge. He's been offered deferred adjudication from the state. He's accepted it pursuant to the court's approval. As part of this federal judgment, after serving 15 months, he was placed on supervised release for 3 years, which I'm asking the court to run that concurrent with this federal case. And that in the event, unlikely event, I believe, he were to be picked up on a violation of probation in this court, that any time served in federal court awaiting disposition of that case be credited towards any time given in that case, in the event he's sentenced.
All right. Do you have any children?
Yes, ma'am.
What are their ages?
4, 3, 2, 1, 6 months.
And where are they? Who are they with?
Their mothers.
How many mothers?
3.
All right. That is not Black excellence.
And she circles right back to that shirt. This isn't just a fashion critic, it's Judge Boyd delivering a life lesson. She's saying, don't wear words you're not living. A powerful moment, and you can tell it hit him different.
The fact that you're here is not Black excellence.
This moment is pure theater. Judge Boyd ties the slogan back to his life choices. She's not just judging his crime, she's judging his example as a man, a father, and a role model. It's bigger than the Lewitz legacy. And honestly, this is where the gavel hits harder than any sentence. Viewers, do you think the judge crossed the line, or was this the wake-up call Cornelius needed?
Unless that's the name of a building, but I'm assuming it's not. So you are not showing Black excellence to your ancestors or to your mother, your grandmother, or anyone. You understand?
Yes, ma'am.
So don't wear Black excellence if you're not showing it.
Yes, ma'am.
All right. Are you employed?
Yes, ma'am.
What do you do?
Pack and moving, Apple moving service.
Okay. All right. This is what the court is going to do. Court will sentence you to 3 years deferred adjudication. There's to be no contact with Jose Aguilar. There's to be restitution, if any.
This sentence is packed. Parenting classes, community service, restitution, strict probation. This isn't just punishment, it's rehabilitation. Court's basically saying, step up as a father, or step into a prison jumpsuit.
To FedEx.
Here's the difference between punishment and rehabilitation. Parenting classes, community service, restitution. These aren't just hoops to jump through, they're tools. Judge Boyd is drawing a roadmap. Be a present father, hold down a job, give back to your community. Fail, and the backup plan is prison. It's that simple. The choice is his, but the consequences are massive.
Regular reporting by Zoom or in person. Regular UAs. 200 hours of community service restitution. There's going to be parenting classes. Once he completes parenting classes, that will be deemed to be satisfied. Field visits.
And that ending, pure courtroom wisdom. If the answer is yes, don't do it. If the answer is maybe, don't do it. Forget law school, that's life school. Cornelius gets probation and a second chance, but one mistake could still cost him 20 years, justice, mercy, or both. What do you think? Did the judge give him too much grace, or the wake-up call he needed? Drop your thoughts in the comments. Hit that like button if this breakdown had you hooked, and don't forget to subscribe for more courtroom cases that reveal the drama behind the gavel.
One time per month for 3 months. And probation, if you all want to check with the federal government and see how their field visits are, you may not have to do any if they're doing them as well. So if you could check with them. There's to be no contact with